Thank you, Your Honor. My name is Elizabeth Kuhn, and I represent Ms. Jody Averin. This is a domestic relations case, and I think the most important thing that we need to realize as I go through some of the procedural parts of my argument is that at the end of the day, we have a little boy, Brandon Garton, who is about to be 12, or excuse me, is now 12, and will be 13 this September. What I believe this court has asked me to do, we have the first appeal, which is direct appeal because it concerns custody of a child. Then there is a subsequent appeal with a motion to set aside an order of attorney's fees arguing supersedis, and that motion was denied and the subsequent appeal followed. This court specifically asked me whether that was subject to a direct appeal or whether that was subject to the discretionary application procedures as it relates to 9/11/60. I submit to this court that 9/11/60 is subject to the discretionary appeal process, and I do agree with my brother that that is a discretionary appeal process. However, I do want to point out to the court that particular order which issued an award of attorney's fees in a contempt action, a dismissal of a petition for modification action, that supersedis applied. That being, supersedis is a general rule of this court, and I believe that my brother is trying to argue an exception to the rule, and I would like to point the court to two cases, specifically the supersedis issue in an opinion by Justice Hunstein in Panaris versus George, which was cited, 284 Georgia 483, and this is actually a case in 2008 that was brought by Mr. Webster arguing my side of the case. This court, in the same and similar circumstances, held, the record reveals that after the Panaris filed her application to appeal, the trial court issued two orders, one purporting to deny motion for reconsideration and award additional attorney's fees, and the other purporting to vacate its original order on the contempt motions. And this court held the trial court lacked jurisdiction to issue these two orders due to the pendency of the application for appeal. And in this case, it's our position that the court erred in awarding those attorney's fees. The court should have stayed the issue of attorney's fees. I'm not saying the court doesn't have the authority or the jurisdiction to eventually order, but we needed to see what happens in this appeal. Those attorney's fees specifically relate to the issues on appeal, which is the contempt and the denial of Ms. Averin's petition.
In this particular case, did not the trial court reserve the attorney fee issue at all?
Yes, Your Honor. In this case, the trial court did reserve the issue of attorney's fees, and that is proper. Had the court issued an award of attorney's fees, the court could have said pending the outcome of the appeal, or this order is stayed pending the outcome of the appeal. Unlike other cases where this court has carved out exceptions, this is not an attorney's fee issue that stands independent, and I believe that's what the crux of the issue is with regards to the supersedis. Also, I would like to point out to the court that one of the cases as it relates to the motion to set aside the attorney's fees, there's a potential argument by the Mr. Webster that my client, because she didn't file it immediately within 30 days of the order, that she was somewhat negligent or didn't exercise due diligence, and he relies on the Marshall versus Marshall case, which was 257 Georgia 494. However, this court actually overruled that as it relates to 9/11/60, the Marshall case is no longer good law. In that case, it was Scott versus Scott almost 10 years later. That's 282 Georgia 36, and in that case, the court specifically held negligence or fault on the part of the movement is not a bar to the movement's claim as it relates to 9/11/60. And an appeal acts as a supersedis, and it deprives the court of subject matter jurisdiction to issue that award of attorney's fees. And I ask that this court follow its general Supreme Court for guidance on certain issues. Specifically, are there limitations to the rule of sequestration? At the trial court level, Ms. Averin invoked the rule of sequestration, and the trial court held, well, you didn't subpoena that witness, so you cannot invoke the rule. Mr. Webster correctly points out in his brief that it's my obligation and duty to show to this court that there was harm, because if there's no harm, there's no foul, and that makes sense, so that we're not just litigating silly issues. However, if this court does reverse and remand the case, and this particular witness was deposed, this witness should not be allowed in the courtroom. Expecting litigants to subpoena each and every witness would cause substantial financial hardship. And domestic relations cases, unlike criminal cases, unlike other civil matters, sometimes we don't know what's at issue until we get in the courtroom. And expecting us to know the ins and outs of a case when we have a temporary hearing before the court, sometimes within 15 to 30 days, it doesn't make sense to say the rule of sequestration only applies if we subpoenaed everybody who's appeared at the courtroom. And that's just a practical matter. Also, another practical matter, which those of us down in the trial court level would like some guidance and some instruction, are guardian ad litems. 2 points. 1, the fees. 2, who can the guardian talk to? Specifically, my client, Ms. Averin, had primary physical custody of this little boy. She did not have final decision-making on medical, which is the contempt issue, which I'll get into briefly. With regards to the court's order on the guardian, my client, as the primary custodian, authorized release of his medical records. Opposing counsel objected, and the court declined to allow the guardian ad litem to speak to the child's therapist. That doesn't make sense. The rule, Uniform Superior Court Rule 24.9, requires the guardian ad litem to obtain a release or a court order to speak to medical professionals. How can the guardian adequately represent the interests of a child if he or she, as the case may be, is not permitted to talk to a therapist or a counselor absent the consent from the non-custodial parent? That's another issue, and I haven't found something that's come out of this court addressing that. The most important issue in this case is that Ms. Averin has attempted to modify custody of this little boy on 2 occasions. It's important to point out to this court that the last child support order was entered in 2006. That was prior to the enactment of the 2007 child support guidelines. In 2006, we had 2 kids. We had Brandon, and we had his older sister, Nicole. Nicole, in the second case, let me back up. Nicole was awarded custody in the 2006 case to Mr. Garten. Ms. Averin had Brandon. So here we are, and the new child support laws really spells this out because it was a problem under the prior law. We have a split custody situation. We have a mom with an ability to make $30,000 a year according to the order. We have a father at that time who was making excess of $300,000 per year. Nicole graduated. I argued to the trial court that her graduation constituted a material change in circumstances and condition that would warrant a modification of child support. In addition, I argued to the court in the petition and in procedural arguments that now Brandon has reached the age where he attends camp. In the current court order, Ms. Averin has final say on extracurricular activities. Mr. Garten, in the current order, gets to pay for them if he wants to. This court has held, we don't like when somebody holds the purse strings. That's exactly what happened in this case. So we now have a change of circumstance under 2 prongs. Number 1, does the graduation or emancipation of a child who is in one person's care constitute a material change? I think absolutely yes. Otherwise, a party or parent can never modify in a split custody situation. I don't think that's what the legislature intended. I think as a matter of law, a child no longer becoming eligible or no longer being eligible for child support is a ground to modify under the child support statute. In addition, the evidence was clear and undisputed that Mr. Garten refused to pay for swimming, refused to pay for camp, refused to pay for counseling. This repeated refusal, I believe, in of itself constitutes